All right, good afternoon, everybody. Welcome to the House Environment and Transportation Committee. We have double-header briefings today, but first, most importantly, let's all wish our committee clerk, Angelica, a happy birthday.
Happy birthday!
Thank you for spending it with us. We will start with renting with a criminal record, background checks, screening, and advertising. Our first panel is the Department of Housing and Community Development. Secretary Day, you and your team, please go ahead when ready.
All right. Mr. Chair, Madam Vice Chair, members of the committee, good to be with you again. For the record, my name is Jake Day, the Secretary of the Maryland Department of Housing and Community Development. Always a pleasure to be back here. I have a couple of folks with me who are going to be members of the DHCD team who are going to be available to answer questions and who I may tap for additional comment as I go through my presentation. To my right is Assistant Secretary of Policy, Scott Gottbrett, and to my left is Assistant Secretary of Homeless Solutions, Danielle Meister. I think Assistant Secretary Greg Hare will be here in a minute as well. If you don't mind, we might bring him to the table. Look, I want to start off by saying that it's always a pleasure to have these conversations with you. Appreciate the level of seriousness that you take housing issues, and this is a really critical one. When I was appointed to this job, one of the core objectives that I established for our department was to pursue shelter for all, that every human deserved the dignity of a roof over their head, and it should be safe, affordable, and accessible. So I believe that shelter is a human right, and I have tried to share that everywhere I've gone over the course of the last 2 years, almost 2 years. Our goal within that objective is to end chronic homelessness in Maryland and to ensure that all Marylanders have an opportunity to find safe and stable, affordable homes. And this includes formerly incarcerated Marylanders trying to reenter society and rebuild their lives. Currently, individuals with criminal records face significant barriers to finding and securing safe housing. And this it's a huge factor in their ability to achieve a second chance at life and ensuring that that second chance is successful. Safe, stable, and affordable housing allows returning citizens to establish the foundation necessary to secure employment and to pursue educational opportunities. Many of those individuals who are unable to secure housing upon release are often left with the choice of asking a friend or a relative for a temporary place to stay. If that's not an option, many remain unhoused, and that carries a much higher risk of recidivism and rearrest. Formerly incarcerated individuals are 10 times more likely to be homeless, 10 times. And because individuals who have had contact with the criminal justice system are disproportionately Black and low income, those racial disparities in the criminal legal system further contribute to inequities in housing access. To reduce the housing barriers Marylanders with a criminal record face, DHCD partnered with the Vera Institute for Justice to assess the problem and to develop solutions. Since 2017, the Vera Institute has collaborated with public housing authorities in 12 states to decrease housing barriers for people with conviction histories. We partnered with Vera through their new Opening Doors to Housing initiative, and DHCD was the first state housing department to do so. Our goals were as follows. Number one, to understand the scope of barriers and challenges faced by people with a history of arrests or convictions when trying to access affordable housing in the state. Number two, to explore modifications to the tenant selection policies that we adopt and the qualified allocation plan to expand eligibility for individuals with conviction histories. And third, to develop policies to remove barriers to state-funded affordable housing for people with conviction histories. So DHCD has considered, quote, persons with conviction histories as a group that could be designated as a target population in relation to our affordable housing development programs. But until this recent partnership with the Vera Institute, our engagement with that population and their related advocacy groups has admittedly been very minimal. Outreach was essential. So the Vera Institute led, as a part of their award to us, the Vera Institute led a series of stakeholder meetings with housing and social justice organizations that included the Baltimore Fair Housing Group, Ball and Secur's Community Works, the Community Development Network of Maryland, Enterprise Community Partners, the Equal Rights Center, Housing Options and Planning Enterprises, or HOPE, the Maryland Affordable Housing Coalition, the Maryland Justice Project, No Struggle, No Success, Pivot Baltimore, and Return Home Baltimore. These meetings also included partner state agencies beyond DHCD, including DPSCS, the Civil Rights Division of the Maryland Attorney General's Office. Through this process, Vera developed a series of recommendations for DHCD to adopt and implement, including modifications to the QAP, the Qualified Allocation Plan that I mentioned, which sets the rating and ranking parameters for the department's application process for federal low-income housing tax credits. And it also does the same for the application of state rental housing funds, which are paired to low-income housing tax credits. Additionally, HUD released guidance in April of last year on the impact of tenant screening services on fair housing. Specifically, what they did was they examined data for conviction histories, eviction histories, credit, and the subsequent impact those factors have on racial equity in housing. We included a lot of HUD's guidance into our policy, along with Vera's suggestions, since we received both around the same time. We believe that action, this type of action at the state level, is critical. And I want to note that we believe this is more important now than ever before as federal protections are being rescinded. I'm going to take just a quick second to ask Assistant Secretary Meister to talk about a recent rescission of federal rules from HUD that affect this population.
Sure. So making sure this is on. Recently, HUD has already rescinded several rules. Even today, the DOJ has halted civil rights investigations. So one of the challenges that we have faced is even in federal rules for federally financed programs, we're seeing those already start to be retracted. Most recently, HUD rescinded proposed rules around removing or reducing criminal background screenings as part of federally assisted programs for vouchers for public housing. And so those federal protections are actively being reduced, rescinded, and we expect that to continue over the coming months.
Thanks, Daniel. So in order for Maryland to address the problem, Vera made a series of recommendations, and I'm going to cover those really quickly. The first recommendation was that DHCD would develop and implement an inclusive tenant selection plan as a threshold requirement, or one of the requirements in order to be funded at all, as a part of the competitive scoring criteria in the department's qualified allocation plan. That would limit the use of criminal history screening to specific types of convictions within established timeframes and allows applicants to undergo an individualized review of their conviction histories. The second was that we should improve funding streams and interagency collaboration on permanent reentry housing paired with the necessary supportive services. Data shows that individuals who were homeless upon entry into the correctional system are highly likely to immediately return to homelessness upon their discharge. Additionally, once an individual has been in an institutional setting for 90 days, they are no longer eligible for federally funded homeless programs, making alternative funding essential if we're going to house those individuals. And third, the recommendation was that we should increase interagency coordination to address other barriers, a category of other barriers that were identified to housing. If you jump to the next slide for me. In response to Vera's recommendations, DHCD placed increased focus on issues related to renting with a criminal record as it worked to revise this year's qualified allocation plan. During the listening sessions for the QAP process, DHCD received 10 comments, verbal or written, about returning citizens and tenant screening with conviction histories. While 10 might not sound like a big number, these were substantive, thoughtful comments with lots of detail behind them that provided perspectives from partners, collaborators, and those working in this space to DHCD. And it represented a marked increase in the level of feedback that we get on this particular type of topic from past years, which, by the way, has been zero. Half of those comments that we received of the 10 were from advocacy organizations, and half were from constituents with lived experience. Jump to the next slide for me. As a result of our engagement with Vera, DHCD updated our tenant screening policy for all multifamily properties that have received or will receive state funds. Under the updated policy, state-funded affordable multifamily communities must develop a plan detailing all their tenant screening criteria. That plan must be transparent and publicly available, posted both online and at the property. Under that plan, properties can no longer consider the following factors in screening: juvenile records, pardoned or sealed records, or convictions for crimes that are no longer illegal in Maryland. And if a prospective tenant does have a conviction in Maryland, screening must include an individual assessment of their criminal record so that we're not casting a wide net that inadvertently holds people back based on past actions. All DHCD-funded multifamily properties were required to submit their updated screening plans by January 1, and so review of those plans is ongoing. We'll also continue. Mind jumping to the next slide. We also plan to continue to strengthen our partnerships, as I mentioned, DPSCS, and also the Department of Juvenile Services. We're working in close collaboration with DGS on a number of other place-based programs, revitalization efforts, efforts to address housing instability elsewhere. So this is a natural partnership for us. In addition to coordinating these coordinating efforts relating to returning citizens, this is also going to help us with our broader effort to address youth homelessness within the state. So finally, in addition to direct agency action, we're going to continue to support other state and federal initiatives to reduce housing barriers for returning citizens through policy, leadership, and legislative advocacy, which brings us here today. We remain a partner that is happy to work with you on thought leadership, on designing future solutions, and to making sure that Maryland is a place that is, like I said, one that believes in shelter for all. So, Mr. Chair, as I transition to answer any questions you have, can I bring Assistant Secretary Hare to the table as well? Okay. Thank you very much.
Are there any questions from my colleagues? Delegate Holmes.
Thank you, Mr. Chair. Mr. Secretary, it's good to see you again, as well as some of your trusted staff. Thank you for being here. I, like others, are paying close attention to some of the suggestions from the federal government. And I was just wondering if you have had somewhat of an in-depth look to see how that might affect some of the requirements or requests that you're making here. I'm hopeful that we might be able to put some type of shield to protect these, but I'm not sure if that's viable or not. So I'm asking, have you decided what can and cannot be protected here in Maryland?
Delegate, great question. I think it's a dance that we are just starting to learn how to dance. I'm going to lean on the other three way smarter people at the table to get into specifics. But what I can tell you is that for the last few months, staff has been working hard at identifying the things that we can anticipate based on 2017 actions, actions taken early or during the last Trump administration. We have also taken a hard look at what might be done differently this time and tried to anticipate how that might affect us. I think we also have to look 2 or 3 steps ahead and to ask not only what has been done in the past and could be repeated, but also our counteractions, the things that we have done to protect our citizens, that we believe as a state are protections for our citizens. What counteractions might the federal government take? And so it's a dance, right? So we have some specific answers to you. As Assistant Secretary Meister mentioned, there are some actions that have already been implemented just in the first few days of the administration, but I'll hand it over to Greg and Danielle and Scott to offer some thoughts on this.
Yeah, yes, sir.
Good afternoon. The Assistant Secretary Hare, Delegate Holmes, to answer your question, as the Housing Credit Agency and as the Housing Finance Agency, we do have flexibility as it relates to our compliance requirements. And so a lot of the things that are in our tenant screening and selection criteria are really what we believe to be really threshold and baseline criteria, including things like reasonable accommodations and really transparency around the process. So we believe that we have, really broad authority within these programs. And I think it's really going to be some of the federally funded programs like the housing trees vouchers and others that will be impacted, but the housing tax credit portfolio itself is under a separate umbrella.
Thank you. Okay, I'm sorry, go ahead.
Yeah, just to add to that, I think it's important to distinguish between what regulates the private market for rental housing and what maybe regulates the government-assisted program. So things like affordable housing or rental subsidy programs. You know, at a nationwide level, there's very few, if any, federal protections around the private rental market. So an individual applying for housing, even with a subsidy program, you know, a landlord has large discretion about what kinds of criminal convictions to consider, how far back to look. Most of the time, we find, this is my personal experience, you know, working in the homeless field, we work to get people rehoused, even when we guarantee rent for a year. And that person has a conviction that has nothing to do with tenancy issues, right? Maybe it was a theft or a burglary a long time ago. It doesn't really speak to how they live in a unit or in a neighborhood or a community or their ability to follow a lease. We still find people are being excluded from housing, even with a guaranteed rent for a year. So the risk to a landlord is relatively low. So when we're looking at the private rental market, there's very few protections for individuals who have a conviction history in accessing those units.
Thank you, Mr. Chair. And if there's anything we can do to help, please let us know. Thank you.
Delegate, to that point, I think we will. We'll just need to stay in contact over the coming months as things develop, whether it's during this session or in anticipation of the next.
Thank you, Mr. Chair.
Delegate Naraki.
Thank you. Mr. Secretary and team, thank you for being here today. I always appreciate you coming out. I do have just some points of clarification based on the slideshow. So could you just give me broad, and we can always talk offline for more specifics, but what is still permissible to look at? What types of crimes, rough time periods that would still be permissible to look at in a background check? And then I do have one other follow-up to that as well.
Sure. Greg, you want to get into the specifics?
Yeah, sure. So here we go. So the criteria that we provided actually does provide some broad, guidance for the properties. And so what we do want properties to consider when they're admitting households into a property is, like Secretary Day said, in the juvenile records, any expunged records, vacated the pardon or sealed records, conviction of crimes no longer illegal. And then the individualized assessment, I think, is the biggest thing that we want properties to consider when they're making these denials. And so we want to make sure they have really transparency around policies. And so that assessment includes the seriousness of the crime and how that would impact other residents, the effect of the denial for other members of the household who would not be housed because of it, the age of the member at the time of the offense, the extent of their participation and culpability, including other family members, the length of time since the offense, the number and nature of the criminal convictions, whether or not the offense was in connection with the rental property, and evidence of rehabilitation for the household member, including, things such as employment or training programs. And so what we want all of our properties to do in this process, and a part of our review process, is ensuring that they have a policy that addresses all these issues, but it isn't a specific direction to say you have to, remove look-back periods up to 3 years or 5 years. I think what we want to do, and as Governor Moore would say, really data-driven, we want to start this compliance process, collect these plans, and start to see what comes of it, and then I think we can further refine the policies in the years to come.
Okay. So, and just to be clear, I think I understand what you're saying there, but just to be clear, so things like child sex offenses, rapes, things like that would still be permissible to take a look at, correct? Because there was a bill last year that would have actually limited the ability to look at certain child sex offenders. I've got 6 kids. Those kinds of things like raise lots of alarm bells to me when we see stuff like that. Okay, so that was, thank you for that. My follow-up, though, is with respect to juvenile offenses, totally understand, certain juvenile offenses, but if we're talking about these kinds of serious things, like if a juvenile were to commit a child sex offense, a rape, certain violent crimes, those would still be able to be looked at because those are in the adult court system. Is that correct?
I believe that's right.
Yes, that is correct.
Okay, thank you.
Delegate Healy.
Thank you very much. I wanted to go back. I'm sorry, I get your name. Danielle Meister. Yeah, you talked about the differences between government subsidized or government housing versus private owners, but we have in law now that it's against the law to discriminate on the basis of a source of income. So if you're getting income from a voucher program or so forth, how does that interact with what you mentioned about private property?
Sure. So in terms of source of income discrimination, that legislation specifically looks at where is the money coming from that would pay the rent. It doesn't consider criminal background or criminal conviction. So
Okay, maybe I'm not explaining this. Would accepting a voucher, for example, trigger these protections, or would they still be some additional flexibility that the landlord has in those circumstances?
around source of income or criminal background?
I'm saying if they're accepting a voucher because of the source of income law,
Right.
they are now entangled with the government in some way. And therefore, regulations about government programs do flow to
Yes.
them in what they're renting out, right?
Great. Thank you for clarifying. Yes. So it would depend on the program that they're receiving subsidy from. But yes, generally, if it's a voucher coming from a public housing authority, for example, there's certain HUD guidelines that set a minimum or a floor around what criminal backgrounds can be considered for a voucher or public housing. Voucher in the case of a private rental market. Obviously, they're not doing public housing. For things like a subsidy that would come from, say, a continuum of care for homeless services. We do a lot of rental subsidy programs. We generally have a housing first policy, so we don't look at criminal background at all when offering someone a subsidy. So yes, a byproduct of participating and receiving income from one of those programs would potentially provide some protections as well as some restrictions, depending on which one it is. Each PHA, each public housing authority has discretion to a certain extent around which kinds of criminal backgrounds they'll consider and accept, which Greg is probably much more equipped than I am to answer.
Thank you.
Yeah, and I guess just to put a finer point on it, as it relates to the two programs, so the Housing Trades Voucher and the multifamily properties we finance through DACD are two separate programs. So if somebody was using a housing trades voucher in one of these multifamily sites that are required to submit the tenant selection plan, that property already has to follow that criteria. But if you're talking about an individual landlord who owns a townhome or single family home and they're renting it through the housing trades voucher program, they would have their own criteria how they would normally screen a household.
Okay, thank you so much, appreciate it.
I think the resultant effect of that is that there are probably a multitude of layers of protections, ultimately down to people having very little direct protection, certainly that the state interfaces with, or even in most cases federal law, other than general protections of their civil rights. So it's kind of a stacking. The most layering of those protections would be a multifamily finance property by the state, which would have guaranteed them certain protections through the adoption of the tenant selection plan and the use of some federal voucher or tool or subsidy that would be affording them those additional protections. That would probably be the scenario. But again, it sounds like there would be layers.
That so that, like, sometimes buildings that have been subsidized, it's only like a 20-year period of time, and then it becomes like market.
Yeah, great question. So yeah, our mechanism for enforcing the things that the characteristics of a property that we finance, our mechanism for holding them to that is the loan. Right. So if they exit that enforcement period at the end of 40 years, and they exit and choose to go market rate and refinance, and then yes, many of those protections go away.
Thank you.
Delegate Ziegler.
Thank you, Mr. Chair. So in terms of the private rental market, I'm guessing that for a lot of landlords, they have a sense of potential liability from accepting a tenant who was previously incarcerated. Is somehow removing that liability from the landlord perhaps an avenue for increasing comfort and making that easier?
Delegate, that's a really interesting question. If the liability were removed from the landlord, on whose shoulders would that liability sit?
Well, that's a good question. I'm assuming the government in some way. And I'm just thinking through, people might feel responsible for somebody's bad behavior, the way you're responsible for someone's dog who bites people or what have you. It was a similar situation.
And I think in society, a neighbor, another tenant would certainly look to their landlord as having some responsibility, whether it was, legal accountability or not. So I think you're right that today that liability would reside with the landlord at least to some extent. So I think it's a question worth exploring. It's something that we can give some thought to.
One possibility, I'm not suggesting this, but just thinking along the lines of if that information were completely withheld from the landlord, that might be a form of, I don't know, that's probably a bad idea. I'll stop now.
Well, that is essentially been the approach of many states and jurisdictions around employment, is that you simply don't ask the question, and by not asking the question, the liability doesn't transfer to the employer in that case, or to the landlord. I think as we are pursuing this with respect to affordable housing, income restricted, state financed multifamily properties, I think we're trying to afford that the property owner, the landlord, the ability to have some rules and boundaries and to consider things that might be a risk to other residents or neighbors within reason, and most importantly, to be transparent about it, to have clear guidelines and to be clear about it, and secondly, to not punish people for things that should not cost them the ability to be housed with dignity, right? So it's a tough balancing act there, particularly as we talk about the transition from things that the state finances to the private housing market. But I do think it's worth exploring. And fortunately, we have a crackerjack division of policy strategy and research, and we can lean on them and other experts at our agency to look into that issue.
Thank you.
And Scott's taking great notes right now, so I'm sure we will.
Thank you.
Delegate Baker.
Thank you, and welcome to everyone. And it's great to see what you're trying to accomplish and do, but I know there's at least one municipality in my county, they have ordinances, laws in place to where the landlord is responsible for the tenant's activities. So if the tenant comes in and they're doing something illegal, they want to hold the landlord responsible. So is there anything in this information we're going to be receiving today to where your organization is going to assume full accountability and support to the landlords that are going to be providing housing to anyone that you're, involving here?
That's an interesting conflict, potential conflict between the municipal rules and the rules for financing a project. I'm not sure. Any thoughts on how those two might interface?
I mean, landlords have a tremendous amount of responsibility to provide housing to all, but they also, again, have a lot of potential setbacks when there's laws in place within that community to where they're going to be held accountable for the actions of their tenants.
Yeah, I think
there should be some possible help provided to them for legal services or what have you. That's just my comment there.
One thing I do want to differentiate between is the criminal history, right? The past acts of a person, and bifurcating or separating that from future actions. I mean, nothing in here should be interpreted as we should let criminal activity occur, right? We don't want future criminal activity to occur. And every person deserves housing, right? Every person should have a roof over their head. And when you are getting state funding to pay for almost all of your expenses, or state leveraged federal low-income housing tax credits, shouldn't you be the first place that is accommodating of those who have not been able to find housing stability? So I think that's I'm giving you a values answer to that, not a procedural answer, and maybe we need to dig into the procedure there and the relationship between that municipal law and state policy. But my gut tells me that, we want to prevent, we don't want any future crime to occur. So I don't know, but I'm willing to look into that because I'm not sure of exactly how to answer that today. Absolutely.
I guess the question, Mr. Secretary, is you have heightened protections. That was, I think, your terminology. Have you had heightened problems? Because I think what we're going to hear from 2 panels from now is that they avoid all sorts of bad things by not doing in the private markets and what you all are already doing around the QAP and other examples you gave. So do you have problems as a result of that? Now, you may be okay with these problems because, as you say, it's a value judgment for you that you want people to have housing. I'm not asking you to say what you think about the problems. I'm just asking, are there heightened issues that are occurring in the type of housing where these heightened protections exist?
Mr. Chair, I don't have data in front of me that would support a per unit basis or per property basis of increased either property crime or personal crime. But I think we could certainly look and see in the literature if there are studies that would support that is a concern. I think we could also produce a panel of Maryland affordable housing developers and property owners who could give you their perspective and opinion on it. Perhaps even find some that are in both the affordable and market rate space who could tell you the difference in terms of tenant activity with respect to criminal behavior in their properties. I think we could produce a panel that could at least opine from a more educated standpoint than I have.
Yeah, because you have a bit of a control group. We're going to hear a lot of hypotheticals shortly, but you actually have a real world sample, so it might be useful.
Sure.
Delegate Long?
Mr. Chair, I have what would probably seem to be a pretty rhetorical question, but I want to put it here for the record. So an individual, no matter what their previous background, mistakes, record, would agree that they do need a place to live, housing, correct?
Agreed.
Thank you.
Isn't that so? I do not see any more questions for this panel, so thank you, Secretary Day and your team. And we will now call up a panel from Renters United Maryland, David Wheaton from the NAACP Legal Defense Fund, Minister Thomas Anderson with BUILD, and Elizabeth Ashford with the Public Justice Center. Please go ahead when you're ready.
All right. Good afternoon, Chair, Vice Chair, members of the committee. My name is David Wheaton. I'm an attorney with the NAACP Legal Defense Fund, also known as LDF. And we're here to present on fair chance at housing, Maryland. So we want to start this by doing some quick facts. We really want to thank DHCD for their presentation, but we want to go a little bit in depth and a little bit deeper into the numbers. So approximately 22% of adults in Maryland have some sort of conviction or arrest history. So this is, about 1 in 5 adults in Maryland have some type of conviction or arrest history. So this is the subset that we're talking about. And this number is also rapidly increasing each year as at least about 83,000 different people are booked into local jails in Maryland every year. And people who are coming home, we know in 2019, about over 70,000 men and about 16,000 women were released from Maryland jails and prisons in 2019. So this is the population that we're talking about that needs places to stay and homes to live in. This right here is pretty much current. This is from the Prison Policy Initiative and this is numbers from 2022 that shows where folks are in the system right now. So we have about 54%, over half are on probation, a little bit over some in parole, and then we have populations that are in our local jails and our state prisons right now, and then some in our federal prisons as well, and then some who are involuntary committed and have juvenile crimes as well. So this is also just a subset of folks again who are dealing currently with some type of criminal history currently. And then the disproportionate impact. Again, so black people in Maryland make up about 31% of the state residents, but 52% of the people in jail, so over half the jail population, and 69% of the people in prison. So over a third, or more than 2/3 of the people in prison are black Maryland residents. And another statistic we want to point out, in Maryland, about 1 in 5 black people who were born in 2001 are likely to be incarcerated in their lifetime compared to 1 in 29 white people. So we want to point out the disproportionality in this as well of who we're talking about as well. So tenant screening today, we want to talk about, who's being screened. Most people, when they go to apply to rent somewhere, they are being screened. They are having some type of tenant screening software that is used on them. So a 2017 survey from TransUnion said that 9 out of 10 housing providers use criminal history screening to evaluate prospective tenants. So most of these screenings, tenant screening software are using criminal history in their screening software where they give a score for a tenant. And another survey found about 8 out of 10 formerly incarcerated individuals reported ineligibility or denial. So they had somebody who denied them housing because of either their conviction history or a loved one's conviction history. So this is, again, a broad subset of people who are dealing with this issue, and this is a widespread issue in tenant screening today. Another thing that we wanted to point out in this is the inaccurate records of this. So again, we talked about how, 9 out of 10 folks have used tenant screenings to be able to talk about prospective tenants and be able to screen prospective tenants. But most of these records have some type of inaccuracy in them. And so if you look, there was analysis that showed that almost 96 to 100% of participants had at least one error in their background check. And so we are also dealing with just inaccurate records. So these tenant screening companies who pull these criminal records, unfortunately, these records have tons and tons of inaccuracies. And one point that we wanted to point you to, this was a nationwide study, and they also looked at Maryland. So Maryland, in particular, found that 73% of records contained at least one error. And again, this varies by states, but the average is about 69%. So Maryland is a little bit above the national average when it comes to inaccuracies in the records. And then one key thing that we want to point out and hit on is that from all the studies that have studied this, is that criminal history does not predict the likelihood of being a good tenant. Again, this, we may think that this has some type of effect, but the studies show that, criminal history, if somebody has a criminal history, it does not predict if they're going to be a good tenant, if they're going to pay their rent, or anything like that. It has no bearing on any of that. And so one of the studies, show that from 2019 to 2013, there were studies that evaluate whether criminal history was a predictor of housing success among people facing homelessness and substance abuse challenges. In all 3 studies, researchers found that criminal history is not a predictor of housing success. And more recently, in 2019, a study showed that was done in Minnesota and Wisconsin, showed again that most of the criminal history categories that they screened for housing success, those categories had no significant effect on housing outcomes. And one other thing that we want to point out is that fair chance at housing is good for public safety. This we have more research that shows. So we know that research shows that stable housing can reduce recidivism and is associated to social costs and improve public safety for the community. In Ohio, again, a Republican state, they have a program called Returning Home Ohio. And despite folks in this program that have higher security level classifications, 40% were less likely to be rearrested, and 61% were less likely to return to prison within 1 year release when members had good and stable housing. By contrast, people who lack adequate housing in the first year, they are incarcerated more than twice than likely to commit another crime than those with adequate housing. So again, giving people a chance to be able to have fair chance, be able to secure safe and affordable housing is good for public safety. It keeps our community safe, and it keeps people who are returning home from being able to have any type of recidivism. And so, in conclusion, want to break down those, again, these big issues. One, that, again, there's a stark disproportionality on Black Maryland residents in this category. Second, most, if all, not all criminal history screening reports will have some type of inaccurate information in them. The third is that, again, criminal history does not predict the likelihood of being a good tenant. And then the fourth is that fair chance at housing, again, is good for public safety, and it reduces the recidivism rate among people who are returning home. And now I'm going to turn it over to Minister Thomas, who's also going to talk about his personal experience as well.
Good afternoon. Thank you for allowing us to sit before you today. My name is Thomas Anderson, and I'm here to represent Build and Turnaround Tuesday. Build Baltimoreans United in Leadership Development is a coalition made up of over 50 or more than 50 religious and nonprofit organizations in Baltimore City and County. Turnaround Tuesday is a job movement that has placed over 2,000 people in living wage and sustainable employment. Over the past 2 years, we've had an opportunity to listen to 700 citizens, returning citizens. These individuals represent just a fraction of the hundreds of thousands of Marylanders that have criminal records. We asked them one question: what is your biggest roadblock after returning home from incarceration? And overwhelmingly, their answer was housing. We heard stories of landlords refusing to rent to people simply because of their criminal records. People wasting their money, applying for 5 and 6 locations with the application fee only to be denied or ignored. Some was forced to lie and have someone else to apply for housing on their behalf. Many of them ended up in shelters and in unsafe living conditions. Others experienced depression due to the inability to find stable housing. Personally, I too have faced housing discrimination. Despite at the time having a good job, despite it paying a good salary, despite me having a 750 credit score, I still, and this is the proof of that, I still faced discrimination for housing. And their reason for denying me was because of my criminal record. Build's sister organization, which is located in New Jersey, helped to pass the nation's first fair chance housing law, which made it illegal to discriminate against a person based on their criminal record. If they can do it, I believe that we in Maryland can do it as well. Let's pass a bill that proves that Maryland also stands for second chances, justice, and equality for all. And so I leave you with this one statistical data. Stable housing reduces the recidivism rate by 40%. Maryland's recidivism rate is 40%. There's no coincidence with those statistics. Thank you.
Good afternoon, everyone. My name is Elizabeth Ashford, and I am a staff attorney at the Public Justice Center. I'm going to be speaking about what fair chance at housing legislation would look like in Maryland. So, fair chance at housing legislation ensures that every individual has an equal opportunity to access safe and habitable housing, even if they have a criminal record. Other jurisdictions, as Minister Anderson has pointed out, also have passed fair chance at housing legislation. Washington, D.C. has a Fair Criminal Record Screening for Housing Act, which prohibits most landlords from asking about potential tenants' criminal backgrounds before extending a conditional offer of housing. Only after that conditional offer for housing has been made can a landlord ask about criminal accusations or convictions. New Jersey has a Fair Chance at Housing Act, and if a landlord chooses to consider an applicant's criminal history, the landlord must do so after making a conditional offer to the applicant. Some key terms to note in fair chance at housing laws are conditional offers and look-back periods. So a conditional offer is when a landlord offers an applicant housing, but that offer is dependent upon certain conditions. So for example, if the tenant meets all other acceptance criteria, the landlord would offer a lease conditioned on passing an allowable criminal background inquiry. A look-back period is the length of time that a housing provider can look back to consider a criminal record when deciding whether to offer a lease. So for example, a 1-year look-back period means that the landlord could only consider a criminal conviction if it occurred within the year prior to the tenant's application. Other jurisdictions have reported great success after implementing fair chance at housing laws. So the Vera Institute of Justice recently completed a report which was titled Fair Chance at Housing, Lessons in Implementation. The report noted that for many residents, securing housing was most challenging immediately following their release from incarceration, and the fair chance at housing laws have allowed them to live and work in a neighborhood of their choosing, pursue a career and educational opportunities, and really build a life for themselves. No housing provider in this study has mentioned any increase in adverse incidents since the passage of the law, and the fair chance at housing laws did not result in significant capacity burdens for housing providers. As you will soon hear, this year, our coalition, in conjunction with Delegate Boafo, is working on a Maryland Fair Chance at Housing Act. This act would ensure that Maryland landlords would be prohibited from requesting certain information related to an applicant's criminal history prior to extending a conditional offer. Once a conditional offer has been made, a landlord may request an applicant's criminal history record during limited time periods, so there would be a look-back period, and a landlord would be able to withdraw a conditional offer under certain circumstances. Thank you.
Thank you. Are there any questions? Vice Chair Boyce.
Thank you so much, and thank you for that compelling presentation. Can we go back to conditional offer? You said they have this in DC?
Yes.
And in DC, do we know any stats on anyone denied after conditional offer is offered? Say that 3 times fast. And the landlord decided, if the person had a criminal record, that they were then denied. And if they were denied, I think back to the question of what sort of crimes that the person clearly has already been adjudicated for, were those?
In DC specifically?
Yes, ma'am.
Unfortunately, I do not have the data regarding the withdrawal of conditional offers for Washington, DC residents.
Okay. And is that type of information kept, sorted, gathered? I'd just be curious, after a conditional offer is given, how many landlords end up rescinding, if at all?
I believe that information is probably available through Washington, DC, but I'm unsure as to the specifics.
Thank you.
Delegate Davis.
Thank you, Mr. Chair. You have heard about the allegations that there's some personal liability from landlords, or have you run into that in any of the cases that you've seen?
Again, yes. So we definitely have heard that before. Again, the data shows us that people who have safe and affordable housing and stable housing are just less likely to commit crimes. So we don't hear about that as much as far as the liability problems. Go ahead.
I'm wondering about the legal concept. The legal concept of someone else being held liability for someone else's actions because of rental. Have you heard of that in New Jersey or with the other state that you mentioned, DC?
Yes, so I mean, landlords do have legal liabilities as far as the people who are going to be on their properties. But again, this is something that we don't see a correlation in, because if you give somebody that second chance, they are less likely to commit any type of source of crime. But yes, you are correct. I mean, there is liability for landlords when they do bring people into their properties, yes.
Okay, thank you.
Delegate Otto.
Thank you, Mr. Chairman. I appreciate your presentation. I'm sort of interested, in the past, having a commercial driver's license. I had to take frequent criminal background checks to maintain my driver's license for hazardous materials. And you talk about the mistakes that are found in these. I'm very much interested. Is there a pattern of certain mistakes that are made more frequently than others, or what types of mistakes are we speaking of?
So yes, usually there are mistakes as far as the inaccurate records, whether somebody was either charged or convicted. So a lot of people who have been charged and had their cases dismissed would still have something like a charge that would still show up in a tenant screening report as if they were convicted. So those are the type of inaccuracies that we've been seeing in some of the reports. And if that answers your question, Delegate.
Yes.
Delegate Healy.
Thank you very much. I'm interested in following up on that because last year we passed a bill into law that actually is supposed to protect the credit ratings companies from and stop them from actually keeping track of or tracking on anybody who has been exonerated or found not guilty, or maybe was just arrested, falsely arrested, and that those things cannot be considered in credit reports. Have you seen any change in attitude or how things are working since that law became law in Maryland?
Thank you for that question, Delegate. We haven't. So this study was done within 2022, so before the law went into place. But again, we have seen, though, in other jurisdictions that have passed similar legislation to what Maryland has, is that sometimes credit reporting agencies are still being able to scrub that data because they take a large subset of data of people who have been charged. They sometimes are not disaggregating that data to show, who has been convicted, and so it's not completely and all the way scrubbed. So we'd be interested in doing another analysis after, but unfortunately, some of those still data agencies or credit reporting agencies and tenant screening reporting agencies still use that kind of aggregate data when looking at people who have had criminal records.
Thank you.
Thank you.
Okay, I do not see any further questions for this panel, so thank you all very much. We will now call up the Maryland Multi-Housing Association and the Apartment and Office Building Association. I'll just say AOBA. Come on down.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association with a rather bland presentation on an interesting topic, if I'm going to be frank. I'm joined to my left by Brian Anlou from the Apartment and Office Building Association of Metropolitan Washington, along with Howard Levin, who is really the subject matter expert, having done tenant screening for 50 years on behalf of property owners. He is a credit reporting agency, so I think we'll have some interesting feedback and should be very, very good on questions, unlike myself, for sure. All right, so U.S. HUD issued guidance in April of 2016 on how housing providers should apply criminal history policies to ensure compliance with the Fair Housing Act. That guidance emphasizes avoiding discriminatory practices and highlights the disproportionate impact criminal history policies can have on protected groups. HUD's recommendation for housing providers' policy design is to tailor their policies, focus on convictions that demonstrate a risk to safety or property, avoid blanket bans based solely on arrests or any criminal record, consider individualized factors such as the nature and severity of the offense, the time elapsed since the offense, and evidence of any rehabilitation or good tenancy. So here's what's frankly prohibited by housing providers in their practices. You cannot rely solely on arrest records without convictions. Blanket exclusions for any conviction, regardless of context, is not permitted. Applying criminal history policies inconsistently or as a pretext for discrimination is not allowed. There is a permissible exclusion in the event that the individuals convicted of manufacturing or distributing controlled substances as specified under federal law. So what are the practical implications for housing providers? You have to design and enforce policies that are evidence-based, narrowly tailored, and uniformly applied. Conduct HUD-recommended individualized assessments, which I will touch on at the end. And that is to balance safety concerns with equitable access to housing. Avoid policies that are indirectly or unnecessarily discriminate against protected groups. So in practice, we are also pro-tenant. We want our apartments rented. We don't want vacancy. We don't want problems. We are pro-tenant, and we're in the business of renting apartments. If an applicant qualifies financially, has rental or mortgage history that is not disqualifying, and has some consumer credit payment history that is not disqualifying, we want to approve them. We want them in our units. Housing providers are concerned with whether a potential resident will injure another person or damage the property. They establish a criminal records matrix when reviewing these records, which is recommended per the HUD guidance issued in 2016. You must place these criminal records in a timeline. It cannot be an automatic decline. Criminal record can be a factor depending on the nature and severity. So I touched on individualized assessment, which I think is probably a really interesting concept. Again, per the HUD guidance, if an applicant is declined, an adverse action notification packet is then sent to that applicant. If the decline is based solely upon a criminal record, the applicant is eligible for the HUD recommended individualized assessment. That's where someone like Howard, Mr. Levin, contacts the applicant, sends an email with a questionnaire. Is the record correct that we have here to confirm that the data is true and authentic? Tell me about it. What else does the applicant want to tell the housing provider? And they also provide at least 3 references to write and validate the person's character. So it's almost like an appeal process, right? And based on Mr. Levin's experience, a significant number of those who go through the individualized assessment process gain approval. So that's my portion of the presentation. I turn it over to Mr. Anlou and Mr. Levin for any comments, and we're happy to answer any questions.
I don't have any comments. I think Aaron covered those well. Mr. Levin.
Thank you all for allowing me to be here. My company is a consumer reporting agency. We are a reseller of the credit reports of the 3 national bureaus, and we conduct screening on individuals who are seeking to get jobs, seeking to lease residences, people who are going to work for nonprofit organizations or who are in volunteer positions. When we do screening for our property management companies, we work with those companies to develop a resident selection criteria. We assist them in developing their HUD recommended criminal records matrix, and we work very hard to try to work with the individuals who have been declined due to a criminal record to have them take part in the HUD recommended individualized assessment. Our clients on the criminal record portion, our clients do not factor, we do not give to them, they will never see, when we do the screening of criminal records, any cases that result in a finding of not guilty, no pros, stet, jury trial parade without having the end result. Probation before judgment is never considered by our clients. Our clients do consider, they will look at misdemeanors and felonies. And all of our clients, all of my clients, and we're a small company. We don't represent a lot of the big firms, but all of our clients who have been with us for many, many years, if they decline an applicant because he has a criminal record and because he just got evicted from someplace and because he hasn't paid any of his bills, they will send him a denial letter. Thank you for your application. I'm sorry, we are not going to be able to accept your application. If they decline an applicant solely due to a criminal record, the required, federally and state required adverse action packet that goes out to that individual offers for them to please take part in the individualized assessment. And my company conducts the individualized assessments for our clients. I will tell you, I wish we did more and more of these. I have reached out to the state government, the cities and counties. I'm a small enough company that people just pay no attention to us. This should be, the individualized assessment should be done on a much wider basis. And the cities and the counties and the state of Maryland should realize that the individualized assessment is not the answer to criminal activity, but it is an answer in ending recidivism. It is one of the answers to help people to come back into the community. As far as the individualized assessment, we conduct them for our clients on a regular basis. I would say that for our property management companies, the individualized assessments that we do, well over 90% of those individuals are approved. Over 90% of them. I'm doing them for our clients. We've done hundreds of them. We should be doing thousands of them throughout the state of Maryland. The individuals have an opportunity to say to the prospective landlord, I cannot make that crap go away, but I need you to look at my journey from then to here. And I need you to listen to me and see me to see who I am today. And it is an amazing piece of work. The HUD preferred assessment packet is very kind of fact-finding. What we have done with this is we have the individual answer all of the questions that HUD needs to be answered. We have them get statements from at least no less than 3 people in their life. Can be a relative, significant other. It holds more weight if it's a manager at work, a pastor, a religious person, a mentor. And I have those people write to us to say, hey, this is how long I've known this person, and this is what I think of them. And these are very meaningful entries. And then we have the applicant himself. And I tell them, don't write a novel, but give me several sentences about what you want this prospective landlord to know about who you are, the guy or the lady that you are today. And they are very successful. These turn out to be a winning effort on the part of the individuals. When we send it out to the individuals, we send it out with a document that says, I deserve. I qualify. Please see me. Please listen to me. The previous testimony was that there are errors in the criminal records themselves, and that can be true. The work that my company does as a consumer reporting agency, we interview every single applicant. Some of the states and cities, they remove the identifiers from criminal records. They get upset if you say that, oh, you provided a record that doesn't belong to this guy, but at the same time, they remove the date of birth from the record. So when Henry Johnson or John Smith applies for an apartment, anyone with a popular name, a common name, it is my job. I don't say to my client, I'm going to send you only the ones that have a date of birth that I know for sure is your person. I don't say to my client, here's all the Henry Smiths who have had a criminal record, you figure it out. What my company does, we vet every freaking record. We vet every single one of them. We do that work for our clients. We talk to that applicant. And the interview that we do with them is very professional. It's inviting. It's easy for them to talk with us. When we send a report to our client with a criminal record on it, there is no mistake. It is 100% correct. We have gone over it with the applicant. What the property management companies are looking for today, they do a criminal record search, they do a credit bureau report, they do verification of employment or income. And we conduct this interview to help put this picture together of the applicant. I'm not sure if there's anything else. Oh, we assist our clients with creating their matrix, their criminal record matrix, and we work with them as they develop their resident selection criteria. We try to be as active. And I look at my company, our small company, as being straight down the middle, being very, very fair to our client and to our applicant.
Great. Thank you, Mr. Levin. I'm sure there will be some questions for you. Delegate Ruth.
Thank you, Mr. Chair. Thank you, Mr. Chair. Thank you to the panel for being here. Mr. Greenfield, I appreciate your sharing the HUD guidelines with us. But given that yesterday there was a purge of the federal government, that virtually every federal agency purged any mention of diversity or equity or fairness from their websites, can you say that that is still the HUD guidelines?
And, well, I think you're asking a bigger question, Delegate. And I'm not really skilled to answer that question, but I will tell you that as far as I know, that HUD guidance from 2016 under the Obama administration is still in effect and still law currently, and that's what our housing providers are following.
So even if it is still law, I don't know that that's something that HUD would enforce. And I did find some Federal Register, and I apologize, I don't have time to look into this further, but where some proposed rules were withdrawn regarding fair housing. One of those would have been about giving 15 days to challenge accuracy and relevancy of information. So, given that these changes are happening, whether or not it's happened yet, it's likely to happen, can we rely on the HUD guidelines going forward?
Again, I think you're asking a much bigger question. I think until it changes, we're going to follow the law. And I don't know what this administration is going to do in any respect. So it's hard for me to calculate what the next step is.
Sure. None of us really knows, but we're here for 90 days. We aren't here after that. So is there any reason why we shouldn't set things into place to protect Marylanders. So if those HUD guidelines are no longer in effect, that we can protect our own people.
I think we have a long history of following what the HUD guidance is, and I think we'd stick to that. But I fully understand your concern.
Thank you so much.
Delegate Stewart.
Thank you, Mr. Chair. So because of the federal guidelines, you guys, and thank you for this, by the way. I thought both presentations, I thought Mr. Levin, I thought your remarks were sensational. I think really interesting stuff. Because of the HUD guidance around blanket bans, isn't it true that basically prospective tenants with criminal records, when they apply for the apartments, they don't know what the policy is of the building, right? I guess, Mr. Levin, you seem poised to answer, so I'll let you take this one. But it's true that basically when someone applies, they don't know what the building's policy is around criminal records, right? They may know it's individualized, but they don't know how much they're weighing it. Is that fair to say?
Yeah.
And so they pay Maryland, prospective tenants with a criminal history, they pay $50 oftentimes, up to $50 in application fees without knowing that they're doomed. Is that also fair to say?
Yeah, they pay an application fee. They have the right to ask the individuals within the leasing office, can you tell me, listen, I have a situation, before I plop my money down, can you discuss this with me? Our clients, again, refer those individuals to me. Mm-hmm. My office on a daily basis conducts 5, 6, 7, 8 interviews, pre-application interviews at no cost to anyone except me for the 10, 15, 20, 30 minutes at a time that I stay on the phone with the people, talking to them about their history, their concerns, and I give them some sort of guidance.
And you should be commended for that. But what I will say is I wish tenant screening companies were like you. I mean, what percentage of your competitors would you estimate actually conduct interviews with applicants before generating a tenant screening report? 1%, 2%? Less?
My company.
Your company. Okay, that's it. So basically, you are the only, because this is the first time I've ever heard of this. And honestly, you seriously deserve a round of applause. It's incredible that you guys are doing this. But what percentage of the tenant screening reports do you think are generated in Maryland do you guys do? Of all the thousands of reports, maybe 0.1?
Well, I do maybe 1,000 a month.
Okay.
I don't know what the total number is.
Okay. So yeah, I mean 1,000. There would have to be hundreds of thousands of people applying for apartments every month in Maryland at least, right? Yeah. Okay. So again, commendations, but I don't want people to be misled to think this is an industry standard. I wish it was. I really wish it was, and I hope that it's competitive for you. I hope a lot of landlords hire you, and any landlords out there, you should hire Mr. Levin because he does it the right way. Anyone listening, I hope your market share goes up so that you are more representative. But right now, I think, isn't it true that you are not representative of what normally happens in this space?
I can't say that.
Okay.
I can't.
Last question. Do you guys use public records information from the courts, scraped from the judiciary that has been sealed or expunged by the courts?
Absolutely not. First of all, we don't have access to it. We will not. We don't do. There are no juvenile records that we even have access to. We would never report it. Our clients would never use it. Sealed, expunged records. They are not ever reported to our clients or factored by our clients.
But you know that Maryland recently passed a law last session that provided for some sealing of old eviction records. Isn't there an opportunity for CRAs to scrape that data prior to the expungement and then generate reports using it even after it's been sealed? And that's legal. I know you may not do that, but isn't that legal for your competitors to do right now in Maryland?
If the record remains today in the judiciary, if it's in there, it can be reported, it can be used. If it has, as it's being expunged, when it's expunged, it's removed from the public record, from the court.
And so you would say if your competitor used an old record that has been expunged, but that they scraped and they accessed prior to the expungement, if that's reported on a tenant, you would say that that's bad policy?
Yeah, I don't know that anyone does that.
Okay, all right, thanks very much.
Delegate Long.
Thank you so much, Mr. Chair. Thank you all for being here today. I appreciate it. I do want to re-echo the sentiments of my colleague, Delegate Ruth. But I just wanted to come from a different angle because I do recall you saying that you are a screening company that tends to do things differently. And given that all screening companies they're not monolithic, and given the fact that literally President Trump has signed so many executive orders ending affirmative action, DEI, all of those things, right? And that we're still trying to lift up the HUD guidance. So I'm getting the assumption that there may be some trepidation or fear from this particular panel on us advancing a policy that will help renters and all the like going forward within the short time span that we're here as a body. So if that is the case, what are your recommendations that we do? Because again, we're living under tyrannical rule for the next 4 years.
I would just suggest maybe you enact what the HUD guidance says now.
The HUD guidance that's going to be challenged in the courts and that has been eliminated.
What I would recommend is that the state of Maryland take the recommendations that HUD had put out and make it law regarding the individualized assessment, that every landlord, regardless of what company you use to do your screening, if you are declining someone based on a criminal record, you must offer that individual that individualized assessment. That would be, if you would ask me, the recommendation. That should come out of this.
Thank you, Mr. Chair.
Delegate Healy.
Thank you, Mr. Chair. Thank you for being here and for very information. I had a question about when we hear that more than 70% of these records have errors in them. We don't know how severe those errors are. Is it a misspelling or is it something that's significant? I understand your company kind of investigates that for people, right? If there's an error that came down from the court records?
Correct. We vet those records. We make sure that any records that are in error are not factored or not sent to the landlord.
So I'm going to ask the people representing the companies, that the landlord operations, do you have legal liability if you are relying on information that's wrong? That, you know, if 70% is a large number of errors on these reports. It's saying people that have a criminal record when maybe they don't. Do you, as landlords, bear any liability for following that as a way to screen people out of getting an apartment?
Yeah, so I can't speak for everywhere in Maryland, but at least in Montgomery and Prince George's County, the answer is potentially, because both counties have enacted some form of a Housing Justice Act that prevents you from making certain decisions based on certain criminal background information. So in Montgomery and Prince George's County, potentially, I will say the Montgomery County Office of Legislative Oversight recently did a analysis of the County Housing Justice Act, and they found despite a very robust outreach and educational campaign by the county, they really only found, they only received one complaint, and despite numerous attempts to follow up with that person, it did not move forward to a formal investigation. And so that's not to say that this isn't happening, but it's to say that at least in county statutes, there are some things that could potentially a landlord or housing provider could be held liable for, but there just hasn't been a lot of that.
So violations of the people's rights under the law are based on a complaint basis? I mean, they're nobody going out and inspecting and seeing if the law is being followed. That's my question. Do you know?
At least in Montgomery and Prince George's County, it is largely complaint-based. Some of it in Montgomery County, which has a bit more robust enforcement and inspection capabilities. There is some proactive engagement with housing providers, and there have been all sorts of things that the county has tried, including like direct mail, for example, but it is largely complaint-based.
Thank you very much.
Delegate Davis, last question.
Yes, thank you. Thank you, Mr. Chair. I am going back to landlord liability. Could you please send me any case law, or send the committee any case law or statutes that relate to landlord liability that would refer to these situations, that would apply to these situations? Thank you.
Is that a yes, guys?
Yes. Yep.
Great. Thank you. Okay, that concludes this briefing. We're going to take a 5-minute break between briefings. And just colleagues, I know it's difficult. Trust me, I know it's difficult. But when you're characterizing national politicians, think about how you would feel if the other party occupied that office and vice versa. Okay? Please. Thank you all. We'll see you in 2:28.
Yeah. Lauren just confirmed it. There is no landlord liability. There is no landlord liability.
What did you mean when you asked that? I know what liability.
Everybody was talking about
The year housing,